that before you would look to any legislative history?
Well, there's no legislative history before this court on 15627A. The entire legislative history is before this court. It's only on 19253B is the first point that I would make. And the second thing is, if the meaning of the statutes are clear when they're all put together, you don't normally revert and resort to looking at the legislative history. But in this case, the legislative history before this court is a very narrow legislative history. It's only the legislative history, 19253B, and it's specifically as to whether or not that statute was meant to, and all that it speaks to is if a voter requests a manual recount, then under those circumstances, what would happen? And it doesn't even speak to the question of what if a voter requests, and this is the question for this court, what if a voter requests a recount by means of the voting system used originally? That's the question before this court, and there's no legislative history before this court on that topic.
Well, of course, we retain the option of requesting the parties submit legislative history.
Certainly.
Would you think that would be something that would be prudent?
I would never deign to tell the Court of Appeals what would be prudent. I was unable to locate anything like that that spoke to this issue, but I'm not, and I don't think you necessarily need to get there if you determine that 19253B states that this happened, or if you find that the electronic votes were simply never recounted in the first place.
It could be that there's no legislative history that deals with this particular issue, but it would be perhaps imprudent to issue an opinion where there's parties haven't submitted legislative history on this particular section and then resolve the ambiguity that's apparent in this section, and then learn later on, perhaps, that legislative history resolves the particular issue before us definitively, one way or the other.
I understand the concern. I would suggest that this has not been a matter that has been likely researched or litigated, and I would suspect that if there was that smoking gun in the legislative history, given that all the parties have gone back and looked at the legislative history and helped one party or the other, I suspect the court would be seeing that. I'm not aware of anything like that. And I think that when you look at the entire statutory scheme, it's pretty clear what the legislature was trying to do here. They're trying to say you can do one or the other, and they just simply didn't set themselves up for tactical recounts.